This is State versus Ortiz, and I assume we have the state and the defense ready to go, appellant and appellee.
Yes, Your Honor.
Okay, all right, and I
Yes,
wanted to
Judge.
remind you, excuse me?
I was just saying yes, Judge. Good morning.
Okay, good morning, good morning. I just wanted to tell you, you each have 15 minutes, and you may reserve up to 5 minutes for the appellant. And I wanted to make sure you can all hear me and hear the other judges, and we can hear you. So I just heard you. So everybody else able to hear?
Yes,
Judge Hensel, Judge Schaefer?
Yes.
Okay. All right. And so I would just ask you, when you're done with your oral argument, if you would mute yourself so that nobody else can hear you at that point.
Yes, Your Honor.
Okay. Thank you. Okay, now I got you. All right. So you have 15 minutes and you may begin. Just let me know if you'd want to save some time for rebuttal.
Yes, Your Honor. Could you let me know when 10 minutes are up, if I get that far?
Yes, that's fine. Mm-hmm.
Thank you, Your Honor. I'm attorney Kenneth Ortner. I represent Adam Ortiz. My bar number is 0069726. Your Honors, this case began on December 19th, 2016. Adam Ortiz was at his grandmother's house in Lorain with some friends of his. Among those friends was Antonio Robles, his second cousin, and DeAndre McDowell, a lifelong friend since elementary school. These men had other friends over there as well. These people were playing with real guns and smoking marijuana. During the course of this playing with guns and smoking marijuana, Antonio Robles and DeAndre McDowell began to wrestle over a live gun that Antonio Robles possessed at that time. The gun was fired somehow, and DeAndre McDowell ended up dead. When the gun went off and DeAndre was dead, everyone in that house ran. The only one that didn't run was Adam and possibly his girlfriend, who stayed at the house, which was Adam's grandmother's house, where Adam lived at the time. Adam could have called the police at that time and avoided a lot of trouble for himself, but he didn't. He attempted to clean up the crime scene. He moved the body, he moved some guns, he did some other stuff to clean up the crime scene. Excuse me, Your Honor. And in doing so, in cleaning up the crime scene, he committed one act. He had one intention. His intention was to clean the crime scene. He didn't have a separate intention to move the body. He didn't have a separate intention to move the guns. He didn't have a separate intention to hide separate pieces of evidence. His intention was to clean that entire crime scene. There was only one harm, and that one harm was that the state was prevented from collecting evidence that they might have liked to have. And these crimes were not committed separately. They were committed all at the same time, one course of action on the same day. So they should be considered as allied offenses. Now, Antonio Robles, the person who actually killed DeAndre McDowell, went to trial, refused to take responsibility, and was sentenced to a 3-year gun specification and 3 years for the underlying charge of reckless homicide. So he got a third less sentence than Adam Ortiz, when all Adam did was clean up the crime scene. Now, we have a right to appeal in this case because the Supreme Court case of State versus Underwood states specifically that if this sentencing court sentences persons to allied offenses, that they have a right to appeal in spite of any other code section. Also,
Counsel, let me stop you just for a minute, though,
yes,
because the whole issue really in this case, though, boils down to, doesn't it, because he did plead to these offenses in return for a community control, and then if he violated community control, 9-year sentence. Why is that just not binding and overrides everything?
for a lot of reasons, Your Honor. One of the reasons is, as the trial court itself stated in their hearing, they said in the first community control sanction hearing where Adam was terminated from CBCF for testing positive for marijuana, The trial court said themselves that that 9-year sentence he sees it as a ceiling. He does not see it as an ironclad agreement. And in fact, in that instance, he gave Adam 30 days with credit for time served at the county jail, which proves that the court did not believe that that sentence was a mandatory sentence. In addition, the Supreme Court in Underwood said, even if the parties agree, even if the court sentenced the person to the agreed upon sentence, it is still contrary to law if the court sentence is to allied offenses of similar import, and that appeal can still be brought. That is specifically what the Underwood court says. So you have two authorities, Judge. You have the trial court saying at the first community control section violation that the sentence, that 9-year sentence, was not an absolute sentence, that it was only a ceiling, and that he believed that the last judge did not mean it to be an ironclad agreement. And secondly, you have the Underwood court saying that anytime the court sentenced somebody for allied sentences of similar import, that defendant can appeal, and it is contrary to law. And because it's contrary to law, it's not enforceable. No more than a contract to kill someone would be enforceable. You can make that contract, Judge. You can say, if you do this, we agree that I'm going to kill you. But when it comes time, that contract is unenforceable, the same as this plea agreement is unenforceable.
But the difference is, obviously, is your client wanted this community control. And he and the attorney, I can't remember if it was you or whoever, it doesn't matter. The point is, his counsel had to realize at that point in time that there were arguments about allied offenses, and that, you know, otherwise, if they were allied offenses, there was no way you could even reach 9 years.
Even if the attorney realized it, and even if the defendant realized it, which I don't know would be true or not, the fact is you cannot make a contract that is contrary to law. This contract would be contrary to law. You cannot, the legislature has said, you cannot sentence a person for allied offenses of similar import, which these are. So I could agree, we could make it a contract. I could agree to do something, anything illegal, but it would be unenforceable. The fact that the contract was made does not make it an enforceable contract. These are allied offenses. And furthermore, Judge, when you look at what the law says about similar sentences for similar defenses in similar circumstances, this also violates that. You have Antonio Robles, who's actually the one who pulled the trigger, who actually killed this young man, who's doing less time than another person who had no criminal history and has no crime of violence. And there's no crime of violence charged. All he did was clean up the crime scene, and he got substantially more time. He won't be eligible for judicial release in under 5 years. Antonio Robles will be. And he's
Excuse me, I have a question. Can I ask a question though? But when Mr. Ortiz was sentenced, he hadn't already committed a couple of community control violations. I mean, this was subsequent to him being sentenced in the first place. So that this isn't just the fundamental crime that he was sentenced on. This was in addition to that, he committed community control violations. He'd have been out on community control today if he hadn't committed the violation. So he knew going into it what the consequence was. So it's not the same set of offenses that sent him into jail for 9 years.
Whether he knew that the possibility or not does not make it legal. It doesn't make it not illegal just because he knew ahead of time, just because he agreed, any more than anything else illegal that you can agree to do would make it enforceable. And the fact is for the underlying crime that he got that he got violated for, he got 1 year concurrent time for. So that judge obviously didn't see it as a serious enough offense to sentence a person in the range that you would sentence a person for a felony of the first or second degree.
About the state's contention that this is not a felony of the first, it's a special felony.
It's a what? Excuse me, Your Honor?
Different case. Was this the one where the state's alleging it's a special felony?
No, Your Honor.
Oh.
I apologize, Your Honor. Just okay. I understand you do a lot of cases, so do I. But so this is a case where the most serious charge he was convicted of is a felony of the third degree, and he's going to get 9 years. You'd have a hard time finding anybody in the state, probably in the country, with no criminal record, no prior criminal record, getting 9 years for these type of charges, whether it's a community control sanction violation or not. So he's being treated differently than everybody else, which is exactly what the court and the law doesn't want. On the front of the Supreme Court, the saying is equality under law, equality under the law. That means that he should be treated the same as everyone else. And in spite of his own bad contract, which is unenforceable because it's contrary to law, it's illegal, he should not be, there should be no way to enforce that contract. Do you have a question?
As it relates, counsel, to the to this argument, which is not the allied offense argument, has he not waived or forfeited this argument prior to this point?
Your Honor, waived the argument about crimes of being in similar circumstances. Is that what you're talking about?
Yes.
What I don't understand
at this point.
No, no,
Well,
he can waive that no more than you can.
Go ahead, counsel. Go ahead.
Judge, I don't believe, I mean, I don't believe you can waive a law. I don't believe you can go, oh, this is the law, but I don't care about that law at this time, so I'm just going to waive it. This is a law that's set out in the code, and the court is in the position many times of protecting people from their own poor decisions, as you know. And I don't think that you can waive that, Judge. And on the case that I cited, Underwood from the Supreme Court, they agree that any time that a court sentences persons on allied offenses, it's an appealable issue. You don't, oh, I'm sorry, I got off, I forgot we're talking about similar import.
No, it's okay. I guess I was thinking, I guess I was thinking that this argument, is a different argument than the allied offense argument you were previously making. That's why I was wondering if waiver or forfeiture was an issue.
I see. No, I don't think it is. We raised that issue at the first community control sanction hearing and the second community control sanction hearing, and that trial court judge said those were both brand new sentencing hearings. So I believe that we raised them both and did not waive them.
Thank you.
And
Counsel,
because it's a law. Yes.
Counsel, I just want to let you know that you're starting your rebuttal time if you'd like to save the last 4 minutes. Would you like to save your last 4 minutes for rebuttal?
Yeah, I'm just going to say one more thing, and I'll save what time is left. I would like this court not to remand this back. I would just like this court to sentence my client to an appropriate sentence in the range of 24 to 36 months and be done with the case. Thank you.
Thank you. Okay. All right. So the appellee, I see you now. Sorry for all the technical glitches this morning on my end. But at any rate, so you have 15 minutes to respond. And Mr. Ortner, could you please mute yourself so we don't hear you if you haven't done so already?
I will, Your Honor. Thank you.
Thank you. Mm-hmm. Okay, you may begin.
Thank you, Judge Card. Good morning, Judge Card, Judge Hensel, Judge Schaefer. Brian Murphy, I'm Assistant Prosecuting Attorney for the Lorain County Prosecutor's Office, representing the state. This case is about a sentence that, multiple sentences that Adam Ortiz decided was agreeable and acceptable to him, and that the state concluded it could live with. And therefore, it's about a sentence that both parties recommended that the trial court impose. The trial court did impose, and that was legally authorized on each of the counts, the 6 counts that's before you. And therefore, this case is not, this court does not have jurisdiction to review this case under 295308D. This was a jointly recommended sentence that the trial court imposed, and that is authorized by law. The sentence was 5 years of community control sanction on each of the 6 counts. And for a violation of the community control sanctions, the penalty, the sanction under 292915 was a 9-year term of incarceration. The trial court agreed to impose the sentence. It's absolutely irrelevant that the trial court did not immediately upon a first violation of community control impose the 9-year sentence. The trial court didn't. The state didn't appeal that issue. But the fact of the matter is that on a second violation, the trial court did impose the 9-year term of incarceration as the parties agreed.
Well, counsel, let me just stop you there. Counsel, let me just stop you if you don't care. You say it's irrelevant that the judge imposed 30 days. However, if we say it was mandatory, that this was the terms of the agreement, how did either side? I mean, it seems like you may be arguing that it was not mandated with the trial court, but it was mandated for the defendant.
No, what the state is contending is that the trial court should have, at that first community control sanction violation, imposed the 9-year term of incarceration for violating community control sanctions. And I think the record from that hearing is clear that that was the state's position. The trial court didn't do so, and the state chose to live with it over a marijuana violation. But once Mr. Ortiz was charged with further felony offenses, then there was another hearing, and he knew that 9 years was the term of incarceration that was going to be imposed. These are allied offense and 292911 purposes and principles of sentencing assignments of error before you. Both of these assignments of error regard sentencing. And a recent case, Zazzara, Z-A-Z-Z-A-R-A, it's 2019 Ohio 662. You, Judge Carr, authored the opinion. The assignment of error number 2 controls. It's absolutely on point here. It's from February of last year, and there unquestionably controls. It's on point that a community control sanction was jointly recommended by both parties, just like in this case, with the sanction for violating community control sanction being a specific term of imprisonment. In this case, it's 9 years. I believe in that case, it was something like 18 months. Mr. Ortiz attempts to argue that this was not authorized by law, which he has to do because he has to somehow remove it from 295308D, the jointly recommended revised code section that prevents appeals courts from reviewing sentences. So he uses that to contend that the sentence was contrary to law, because if the sentence is contrary to law, you can then review it, obviously, under 295308, however, A4. But he's saying it's contrary to law because these are allied offenses of similar import. But merger is a sentencing question. Sentencing occurred in December of 2016. The arguments that Mr. Ortner is making today would have been great arguments for him to make at the trial court in December of 2016, not to this court. They would have been great arguments to make during plea negotiations with the state, so that, and not to agree to 9 years. I mean, there's a point at which he was asked by one of you about basically an understanding of what the attorney and Mr. Ortiz had, and his response was he's not sure if Mr. Ortiz understood that. Mr. Ortner was the trial counsel of record. He wrote the sentencing memorandum in this case. He never raised the issue of allied offenses of similar import. He entered into the agreement with his client that on a community control sanction violation, that there would be a 9-year prison term imposed. That's a forfeiture of this argument, of the allied offenses argument. And he doesn't raise plain error. By the way, look back at that Underwood case and look at the facts. The facts in that case are that the state agreed that certain counts merged, and then the trial court sentenced on those certain counts. That's why there was plain error in that case. There was a plain error argument made in Underwood. It's really clear that that's why it was contrary to law, because the state said it was contrary to law. And then the trial court went and sentenced on it anyway. There's also, Judge Hensel, you're correct that there's forfeiture, but there's also waiver. As one of you pointed out already, the only way to achieve a 9-year term of incarceration based on the indictment and based on the 6 counts ultimately after the remand from this court that Mr. Ortiz was sentenced on, the only way to achieve a 9-year prison sentence was to prison term was to sentence consecutively on multiple terms. It's inconceivable that Mr. Ortiz and could have understood through explanation from his attorneys that consecutive sentences were off the table. That can't happen. It was a 9-year term. It wasn't a ceiling. The record's clear. 5 years of community control sanctions and a 9-year term of incarceration upon a violation of community control sanctions. The plea agreement that he entered into, the back end of it turned into reality, that 9 years. And it was inevitable that consecutive prison terms at that point would be imposed based on there only being 3rd-degree felonies whose max time was 36 months, and 5th-degree felonies whose time was, of course, 12 months max. What he's really asking this court to do is allow him to violate a contract, the plea bargain. That's what a plea bargain is. It's a contract. He's asking this court to condone the violation of a contract, a plea bargain. He's as I pointed out, he's making arguments to this court that he should have made to the trial court, and he shouldn't then, if he truly believed these arguments, shouldn't have entered into this plea bargain. That's the simple fact of the matter. He entered into a plea bargain that was obviously favorable to him at the outset, and on the back end wasn't very favorable. And now he enjoyed the benefits for a short time because of his own illegal actions. He's now reaping the non-benefits of his plea bargain. He's the one that decided to enter into this. There was nothing illegal about the plea bargain. He faced the same amount of time based on the counts that were before the court. Frankly, from the state's point of view, the trial court never should have entertained allied offenses arguments at any of the community control sanction violations hearings, whether they were in December of 2017 or in, I believe it was May of 2019 or June of 2019. I'm sorry, March 21st of 2019. The time for raising those arguments had long passed, and they were forfeited by not raising them at the sentencing, and they were waived by entering into that plea agreement because there was only one way to execute that plea agreement. For that plea agreement on the back end upon a community control sanction violation to come to fruition, and that was to sentence consecutively to not merge offenses, and therefore there was a distinct waiver by pleading guilty to those counts as part of the plea bargain, a distinct waiver of the allied offenses argument. Mr. Ortiz is trying to overcome this jurisdictional hurdle, which obviously is kind of strange here. It's the state's opinion that this court doesn't have jurisdiction to reach the merits of the argument, but in a sense, you still have to address the arguments of forfeiture and waiver, and whether the sentence is unauthorized by law and contrary to law, kind of to wrap back around to a conclusion that you are without jurisdiction to hear this case. The argument here was made that the sentence was contrary to law and analogized to a contract to killing someone. The contract to kill someone obviously is illegal. It involves illegal actions. But the contract here, the plea bargain, there was nothing illegal about it. You may think you may be unhappy about the results of it, as Mr. Ortiz is, but there's nothing illegal about sentencing on counts to which he pleaded guilty and then never raised an allied offenses argument, and the sentence was within the statutory guidelines. There's nothing illegal about it. Nothing illegal about any of the sentences imposed on these 6 counts, judges.
Thank you. Now, are you done, or do you have 2 minutes left?
Judge. The one other thing I'd note is that the state is asking ultimately that this court not reach the merits of either argument being without jurisdiction to do so. The state's belief is that at that point, the proper procedure would be to dismiss the appeal, and without any other questions.
Okay.
Thank you. Thanks.
All
Judge.
right. Hearing no other questions, we're going to, if you would mute yourself, we are going to go to rebuttal from the appellant, and you have about 3.5 minutes left.
Thank you, Your Honor. I would say that this contract was illegal. You have a Ohio Revised Code 2941.25, which says that you cannot be convicted of an allied offense. And you also have Ohio Revised Code 292911, which says the sentence has to be consistent with similar crimes committed by similar offenders. And it also talks about demeaning the seriousness of the crime, which I talked about before. I think that sentencing Adam to more time for cleaning the crime scene than Antonio Robles for actually killing him demeans the seriousness of DeAndre McDowell's death. I do believe that. Also, I would like to point out to the court that in State versus Underwood, which both I and the prosecutor have said, their language from that case at one point says, if a sentence is imposed on multiple counts that are allied offenses of similar import in violation of RC 2941.25A, then RC 2953.68D, the statute the prosecutor talked about, does not bar appellate review of that sentence, even though it was jointly recommended by the parties and imposed by the court. That is language straight from that Supreme Court case, which says that if you violate the law by imposing a sentence on somebody for allied offenses, which is a law, so it's contrary to law, that there's still an appellate, that you still have appellate review. And also it is contrary to law because this is not a sentence that's a similar sentence for similar offenders in similar circumstances. Antonio Robles had a criminal history. He had 2 or 3 pending charges which were run concurrent to that 6-year sentence. He got a much better deal than Adam Ortiz. And it does not send out the right signal to the court. If the only signal you want to send out is that you're going to stick to your deal and you're going to punish people whether it comports with the law or not, I believe that might be the wrong signal to send. I think you need to send out a signal that the law, that the court is going to be fair and impartial. And even if someone does agree to break the law, that you're not going to enforce that agreement.
Well, counsel, I'm sorry. Go ahead, Judge Schaefer.
I say, but what you're suggesting, Mr. Ortner, is that we presume that the offenses were all the same thing, cleaning the crime scene. That's what you're saying, is that every one of these 6 offenses were all the same thing, cleaning the crime scene. So that's what you're presuming that we need to find, right? That was all.
That's what they are. He was cleaning the crime scene, yes.
And then that's
There is no separate animus. I'm going to get rid of this. I'm going to get rid of that. His animus was, I have to clean this mess up. He wasn't going to leave the body there and take the guns. He wasn't going to take the body and leave the guns. He cleaned up the entire crime scene, and the prosecutor charged him from each individual step he took in cleaning up that crime scene. They broke it down. If you broke down every case like that, you'd have multiple points on speeding tickets. You'd have multiple sentences on a number of charges where people are charged under different code sections. It's illegal. It's illegal under statute. This is a law. This isn't a recommendation. This is what the legislator said. And as far as the prosecutor was arguing, saying about a distinct waiver, if you look at the case law, is a waiver where a defendant will say, yes, each of these crimes was committed with a separate animus. There was no distinct waiver in this case.
Counsel, you need to wrap up.
Okay, thank you. I would ask the court not to remand it again. Just sentence my client 24 to 36 months within the range of everybody else in the country. Don't punish him unnecessarily because he broke an agreement with the state. That agreement was illegal anyway. Thank you, Your Honors.
Thank you. Thank you to both sides. Thank you for appearing today in our video format. And I'm just grateful we're able to do this. But at any rate, we will take the matter under advisement and issue a written opinion that will be sent to both sides. And gentlemen, I ask you to stay safe and enjoy your day.